G'day everyone and welcome to another ABLA webcast. Today we will be talking about the topic of understanding redundancy versus termination. My name is Kyle Scott, I'm a director at ABLA, and today we're joined with Dominic Mather, who's one of our associates. So today we're kind of jumping in pretty deep for an hour talking about redundancy, termination. Dom, I think this is a pretty kind of critical area of employment law. Quite a kind of foundational first principles topic. So we'll jump into it. We'll kind of try and cover as much ground as we can. Hopefully lots of kind of practical points in there. But everyone, thanks for joining us. And without further ado, I think we'll just jump straight into it, Dom.
Sounds good. So for today's agenda, we're going to run you through the grounds for termination. So that will discuss the various reasons in which the employment relationship might come to an end. We'll then discuss consultation obligations followed by redeployment considerations. Then we'll discuss navigating some legal risks that arise, particularly towards the end of the employment relationship. And then we'll try and get to your questions. Now, we received an influx of questions with registrations, which we've tried to address in the presentation. We're also live. We've got the iPad here, so send any questions you have through and we'll do our best to get to them, but we are time limited, so we'll have a crack.
Yep. Okay. So before we go, I think the focus of today's session is around redundancy, but I think it's important to set the scene, and it's nice to kind of just start from first principles and work through the grounds of termination, the different ways in which the employment relationship can come to an end. We'll then get to redundancy and talk in a bit more detail about that particular ground of termination or reason for termination. But in terms of setting the scene, so when we think about termination of employment, we're talking about an employment relationship at the end of the day. So we've got an employer and an employee. There are different ways in which the employment relationship can be terminated. If we think about the Fair Work Act and unfair dismissal provisions, it uses the language around termination at the initiative of the employer. So if we think about employer-initiated termination, so in terms of broad categories, you can have termination on notice or termination with notice. You can then have termination without notice, i.e. summary dismissal. And you can have different reasons for that. So you can have, conduct reasons, performance reasons, etc. But broadly, we can have termination with notice or without. There's then this thing called constructive dismissal, which could also be called forced resignation. And we'll talk about that in a little bit of detail. And then, of course, we have redundancy. So they are typically the main kind of overarching categories of employer-initiated termination. If we then kind of move over to the other side, employee-initiated. Now, the most common way that an employee will initiate the end of their employment is to resign. I think most people are pretty comfortable with resignation as a principle. Abandonment is a really interesting one because it kind of sits, for the purpose of today at least, it sits on the employee-initiated side of the fence, and we'll talk about abandonment and what that is. But interestingly, there is a case that seems to indicate that abandonment might be, and it might depend on the circumstances, but in some circumstances, abandonment might be seen to be an employer-initiated termination. And the consequence of that is that even where an employment relationship ceases as a result of abandonment, there may be an obligation on the employer to pay notice or to provide notice. So we'll have a look at that, but that's just one to remember. It can be a little bit quirky, abandonment. All right, so Dom, resignation?
Yes, so probably the one we're all most familiar with. This is, as Kyle said, the employment relationship ending at the initiative of the employee. It's important that it's voluntary, and we'll come back to that in a second. But best practice when an employee resigns is that we get it in writing. And if they do provide it verbally, then perhaps we put a request into the employee to have them provide their notice in writing. Yep. And we say it's best practice because if there is a dispute at the end of the employment relationship, and there often is, we have that reason in writing that we can rely on later down the track. Yep. If you're not sure about how much notice an employee has to give, the first place to check is the employment contract. Yep. In some circumstances, though, the employment contract might not deal with the notice the employee has to give. And interestingly, the National Employment Standards don't actually address how much notice an employee has to give. It's different to an employer.
Yep.
However, some awards do prescribe the notice period that an employee has to give. So, for example, the Clerks Award prescribes how much notice an employee has to give.
Yep.
And there's also some awards that allow employers to deduct monies from employees if they don't provide the relevant notice.
Yep.
So coming back to that concept of the redundancy being voluntary, I think it's important because we can have that circumstance where we land in hot water with the constructive dismissal.
And I think that kind of segues nicely into that idea of getting a resignation letter in writing. Now,
Starting point is there's no obligation for an employee to give you a resignation in writing.
Absolutely, it's best practice to get it in writing. It's a nice record to have.
It can be a very helpful record to have in the context of some subsequent argument that there was some constructive dismissal or forced resignation. So you do want to get that. And then you're right. Often, as a practical matter, you see this with clients, employees will resign and they won't give the requisite notice period. So you might have an employment contract, very typical for an employment contract to say an employee may resign by providing 4 weeks notice. Ideally, it says 4 weeks notice in writing, because then we can say, well, look, your contract requires you to provide your resignation in writing. But you do see scenarios where employees just kind of resign effective immediately, walk out the door, and we would get a phone call from a client saying, look, this has happened. They were meant to give 3 weeks or 4 weeks notice. I'm now, it's created operational challenges because they're not here. What can we do about it? My view, the short answer is there's not a lot the employer can do. And if you think about it, as Dom said, the NES, which has those 10 or probably now 12 minimum entitlements, they are entitlements for employees. So if you look at the notice of termination in the NES, those provisions, they require or oblige an employer to provide minimum notice periods, but there's no reciprocal obligation on the employee. So if an employee doesn't provide the relevant notice period, either by reference to the contract or the award, technically that employee is in breach of their contract, and technically you could sue the employee for breach of contract. There's this thing called specific performance where you can, technically speaking, you could go to a court and say, rather than seeking damages for the breach, I'm seeking an order for specific performance, i.e. I want a court to order that person actually fulfill their obligations under the contract. Now, that is very, very unlikely, very impractical. I think there's a few cases. The authorities effectively say that courts will not generally issue orders for specific performance when the contract that's in breach is a contract for personal services, because it's, I don't know, akin to kind of, almost modern slavery to force someone to come to work when they don't want to. It might be different in a commercial context where you might be able to get an order for specific performance under a commercial contract, but you just won't get that order in an employment contract. So if we can't get an order for specific performance, technically we might be able to get some damages as a result of the breach. The problem with that is, as a result of the breach, arguably you've saved money because you don't have to pay the employee the 3 or 4 weeks. If you say you have suffered loss, it can be very difficult to prove how you've suffered loss. And also it's just, we're talking about suing an employee in the local court, your costs are going to outweigh. So long story short, there's not a lot you can do. You're right, Dom, some of the awards do have provision whereby if the employee doesn't give the requisite notice period in the award, you can deduct. My understanding is, my recollection at least is, it's capped at kind of 1 week's wages, so it doesn't allow you to make a huge deduction. Do we need to talk about constructive dismissal?
I think we've largely covered it.
Yeah, so yeah, that's right. No real choice but to resign. My experience is it's rare to see those kinds of arguments getting up from an employee side of the fence. All right, so talked about resignation. We'll talk quickly about abandonment of employment. What is abandonment? Well, it's when an employee just kind of doesn't show up for work without calling in sick, without taking leave, without kind of contacting you at all. So the employee's just a no-show, MIA. If that occurs over a period of time without some reasonable excuse, then it may be the case that there is an abandonment situation. Now, as I said before, from my perspective, this is very much employee driven. The employee has just not come to work. but there's I think probably 2016, 2017 case, Biennius and Iplex Pipelines, for those who want to go and look this up. And I think it was a full bench decision of the Fair Work Commission where they looked at abandonment. And what the full bench said was, yes, the employee abandoned, but at some point the employer had to take steps to actually terminate the employment relationship. So despite the fact that the employee kind of didn't show up for work, what the full bench of the commission said was the employer then went, okay, they haven't shown up, we're going to have to bring it to an end. So in that scenario, what the commission said was the employment ceased at the initiative of the employer, and therefore the employer has to either provide notice or a payment in lieu of notice. So that decision, it's a full bench decision, so we kind of have to, follow that. That is good law, unless I'm, corrected or unless it's overturned by some other higher court. So just be mindful. I think that is a bit of a tip for players out there is if you're relying on abandonment, just be careful that in certain circumstances, it might be viewed as being a termination at your initiative, therefore triggering notice. The other thing I'd say about abandonment is, I think let's say for every 10 phone calls I get from clients saying, oh, we've got an employee who's abandoned, I'd say 8 to 9 of those times out of 10, I would say to the client, you're not yet at the point where you can treat the employment as having come to an end. You do need to make steps. And I think you're involved in a matter.
Yes.
Was it the federal court?
Yeah, it was the federal court. So the circumstances was an employee they commenced general protections proceedings against their employer. And within the set of facts, the general manager was quite unwell. He had, suffering from a mental disability, and he provided the medical certificate for the Monday, which covered him for the Monday. However, his condition deteriorated over the Monday, and he subsequently took Tuesday, Wednesday, Thursday, and Friday off. He didn't make contact with his employer, and he didn't provide any notice. He received an abandonment letter on the Friday, essentially purporting to terminate his employment on Monday if he didn't turn up.
Okay.
Now, in those proceedings, the judge was scathing of the respondent's general manager. I certainly would not have liked to have been cross-examined at that point in time, but I think it perhaps shows a bit of, shed some light on the court's view on abandonment, a bit of a reluctance to enforce it maybe.
Well, I think that's right. I think sometimes employers as well see this almost as not a get out of jail free card, but it's like they go, oh, here is an avenue by which we can cease the employment of someone whose employment we would like to cease. This is kind of we can hang our hat on this and use it. More often than not, the advice is, well, hang on, have you called, have you emailed, have you texted, have you sent someone round to their house, have you called their next of kin in the employee file? What steps have you taken to verify what's going on? If the answer is not a lot, then I think you need to do more.
Agreed.
I think that's the short point with abandonment. All right, so termination on notice. What I want to say about this is, I always like to give a bit of a spiel because one of the reasons employment law is interesting is, and some people have probably heard me talk about this ad nauseum, the intersection between statutory law, so the Fair Work Act and those types of things, modern awards, statutory instruments, and contractual law principles. At the foundation of the employment relationship is an employment contract. Every employee in Australia has an employment contract. It's either in writing. If it's not in writing, then it's verbal, and occasionally it can be partly in writing and partly verbal. So if an employee does not have a written contract, it doesn't mean they don't have a contract, it just means they don't have a written contract. They must have some form of verbal contract. So when we talk about termination, and we talk about termination on notice or without notice, like the starting point is we're talking about exercising a right under an employment contract to terminate the contract. And when we terminate the employment contract, we're often terminating both the contract and the employment relationship that the contract binds or governs. So termination on notice, starting point is we would typically go to the employment contract, find the termination clause of the contract and see what it says. A pretty run-of-the-mill clause might be, either party may terminate the employment by giving the other party 4 weeks notice in writing. For employers, you often have the right to pay in lieu of actual notice. So if we think about termination on notice from the employer's side of the fence, the employer can say, Dom, I've decided to terminate your employment. I'm giving you 4 weeks' notice in accordance with your employment contract, which means your employment will cease in 4 weeks' time. That is termination on notice. Alternatively, I can say, I'm sorry, this might be very basic for a lot of people. Dom, I'm terminating your employment. I'm required to give you either 4 weeks actual notice or 4 weeks pay in lieu. I'm going to give you pay in lieu because I don't want you hanging around for 4 weeks. I'll make a payment into your account of 4 weeks pay, the effect of which is the employment then ceases immediately. So that's what we're talking about with termination on notice. Termination without notice is something different, and I think we've got a slide on that. Typically, if you're and the other thing to call out here is contracts often have very broad and flexible termination clauses. So it's quite often to see a clause in a contract that says the employer may terminate the employment at any time for any reason by giving, let's say, 2 months' notice. Some commercial lawyers or some small businesses, basically anyone, to be honest, could look at that clause and objectively, the black and white wording of that clause is I literally can terminate you for any reason. I don't need a reason. So that might be the contract clause, but for employees who are covered by unfair dismissal protections that sit outside the contract, they sit in the Fair Work Act. If you are eligible to bring an unfair dismissal claim, in short, unfair dismissal protections say you will have a remedy if you are terminated unfairly, harsh, unjust, unreasonable. So what that means is even where we have a contract with a very broad right, a very early question to ask yourself when you're considering termination of employment is, and if clients call us, it's a very early question that we would ask, is the person protected from unfair dismissal? So are they eligible? If they are, you need to view that contractual termination clause in the broader context of, well, we actually do need a valid reason to terminate. So what is our reason? Is it misconduct? Is it poor performance? Is it some, incapacity? Is it redundancy? You do need a valid reason. Contrast that with people who aren't covered by the unfair dismissal regime. In those circumstances, contractually, you can terminate quite flexibly. There's no ability for the employee to challenge you on the fairness of that termination. But my experience is where people don't have access to unfair dismissal, they will often try and utilise a general protections claim. So kind of understanding the contractual rights vis-a-vis the statutory unfair dismissal protections is really fundamental, because I've seen a couple of kind of commercial lawyers who say, well, the contract says that, so we're exercising our right for no reason. The termination letter might not have a reason, and then that calls into question what the reason is. And we know with general protections laws, the reason for the adverse action, the reason for the dismissal is critical. That's like the number one critical issue is, why did you terminate? Did you terminate for an unlawful reason or not? And if you have a termination letter that says nothing about the reason, it can create some exposure. So
I think we've got some questions on this slide, if you don't mind.
Yeah, absolutely.
So one of the questions that we received was a question about reasonable notice and perhaps how we can safeguard against it.
Yeah, so really good one to kind of allow me to continue on with my contract versus statute analysis. Every employee in the country has an employment contract. Hopefully it's written. Sometimes it's not. You can have express and implied terms of your contract. Express terms are the ones that are written down or the ones that are clearly communicated verbally. So, Dom, you will come and work for me and I will pay you $35 an hour. So there's an express term that your rate of pay is $35 an hour. Sometimes you don't cover the field and you don't have a contract with all your comprehensive clauses. For example, we might not agree on a termination provision. That's where implied terms come into the equation. And so there is a body of case law in Australia whereby it effectively says, if an employment contract does not contain an express term dealing with notice, courts will imply a term of reasonable notice. So in my scenario here, if I wanted to terminate your employment, there's no express agreement of 4 weeks or 2 months or whatever. I would have to give you reasonable notice. And I've been involved in federal court cases, Federal Circuit Court cases, where long-standing employees of 20 years service, their employment contract was from the 1980s, for example. It said the rate of pay, but it didn't deal with termination. Then when the employer brought the employment to an end, they provided notice in accordance with the NES, which is a minimum notice period. That employee sued, saying, well, hang on, I'm entitled to reasonable notice, which is a contractual right. And under my contract, in the circumstances, 20-year employee, quite senior, reasonable notice in my circumstances is 3 to 6 to 9 to 12 months. So that's why it's important, one, to have an employment contract in writing, and two, to have a termination clause. If you've got an express termination clause, then reasonable notice doesn't arise. But if you don't have it, then you are exposed to what's called reasonable notice claims. Does that make sense?
Yes, it does.
Perfect. All right, I've probably covered most. Talking about contract and statute, so you could have a contractual notice period, but you can then also have, and all national system employees will have, a minimum notice entitlement under the NES. Your contract can have a more generous notice provision. Your contract might, on paper, have a lower notice provision, but that's not lawful, that's not enforceable because you can't undercut the NES. My experience these days is most employment contracts will say, notice in accordance with the NES, which is the sliding scale from 1 to 5 weeks, or 1 to 4 weeks, but the extra week if you're over 45 and you've been there for 2 years. Sometimes, I don't think awards really deal with notice periods. They tend to just refer back to the NES. An enterprise agreement might contain a longer period, but it's typically the employment contract that might contain a longer notice period. All right, so within that kind of construct of termination with notice, we're talking about, for unfair dismissal covered people, you have to have a valid reason. Typically, your valid reasons might be performance related or they might be conduct related. Now, in the context of underperformance, what do we need to do? For award covered people or for unfair dismissal eligible people, we do need to have some level of procedural fairness. If you've got an underperforming employee, you need to kind of be able to demonstrate prior to the point of dismissal or termination that you have had discussions with the employee, you've counselled them, you've potentially given them warning letters, you've potentially put them on a performance improvement plan or a performance management plan or a PIP or whatever people want to call it. You need to probably demonstrate that you've given them so you've had that discussion to tell them where they're failing. You've given them a reasonable opportunity to improve. You've offered them training or coaching and support. You can't kind of, and look, this all comes up in the context of unfair dismissal cases. There's 50 odd commission members. They've all got slightly different views about what's fair. But typically if you say, hey Dom, you're underperforming, I'm going to give you a month to improve, full stop, nothing more, that might not be enough because I haven't said, okay, well, these are the supports we're going to give to you. That, we're going to have weekly check-ins, et cetera, et cetera. So the question we often get is there a particular number of warnings that need to be given? I think there was a kind of myth or a misconception, which is not a terrible myth, which is kind of 3 strikes and you're out. There's nothing in the Fair Work Act about how many warnings you need to give. And it's kind of proportionate to the seriousness of the conduct. So if the person is gravely underperforming, it might be sufficient to give 1 warning, and then if they don't improve, you can validly terminate. If the underperformance is not of a grave nature, then it might be an expectation that you give a couple. Do the warnings all need to be about the same thing? No, there's no kind of hard and fast rules about that stuff. But the position is, if they bring an unfair dismissal claim, you need to be able to demonstrate that the termination was not harsh, and that one of the objects of the Fair Work Act is a fair go all round. So in Australia, we occasionally talk to our clients about the pub test. So it's like, does this pass the pub test? Did they get a fair opportunity? So it's all quite broad. I think the slide talks a little bit about show cause. Just to explain what a show cause process is you might have a performance improvement plan, you might have a couple of warnings. What we mean by a show cause is prior to the point of termination, the employer might write to the employee and say, look, we've formed the preliminary view that termination of your employment is appropriate. However, before we make a final decision, we want to give you an opportunity to show cause why we shouldn't sack you. And it's another layer of procedural fairness where the employee might raise whatever issues they want to raise before you make that decision.
And perhaps on that point, there's a question that's come through on whether the historic failure to manage underperformance impacts your ability to terminate. Do you have a particular view on that?
Well, I think if we're talking about historic failure to manage generally, then absolutely it does have a bearing on whether or not you can terminate, because if there's been an absence of performance management and then you're terminating for underperformance, my starting point is, okay, well, this is problematic because there's been no kind of process. If we're talking about something different, which is, there was a period 3 years ago where they were underperforming and we should have done something about it, but we didn't. And then fast forward 3 years, they're now underperforming in a different way, and we have managed that and we have put in place a process, then I'm not too concerned about the fact that, historically you should have, but you didn't. But it might also mean that if you're trying to convince the Commission that the dismissal was fair or wasn't unfair, you might be hamstrung from relying on something 3 years ago in circumstances where you never put the employee on notice of it. So, the Commissioners, one of the first questions that a Fair Work Commission member is going to want to know is, if you're saying if you're asserting underperformance or misconduct, they're going to say, well, did you tell the employee about it? If the answer is no, then you're kind of behind the 8 ball immediately.
Absolutely.
All right, we might move on. So that was underperformance. If we talk about misconduct, the principles are probably quite similar.
They are largely quite similar. I think the most important point to get across is not all misconduct will justify dismissal. You get a lot of emails from clients where an employee has perhaps misbehaved and they're looking to terminate, and it just doesn't quite meet that threshold. And in those circumstances, you're probably looking at perhaps a warning to make it clear to the employee that what they're doing is unacceptable. And if that misconduct is repeated, or if the employee continues to engage in misconduct, it doesn't necessarily have to be the same type of misconduct, then you could turn to that show cause process. And you'll notice that the show cause process is quite similar throughout all the reasons for when we're bringing the employment relationship to an end, except for perhaps redundancy.
And I think it's about kind of grading the seriousness of the misconduct. So in some of our training, we'll have this slide. I don't think we have it here today, but we'll have a kind of slide which talks about, well, we could grade it on 0 to 10, a sliding scale of how serious it is. If we're down 0 to 3, we might say, well, that's a conversation by the water cooler and a file note or a diary note just to say, look, there was this issue, I spoke to the person, I gave some informal counselling and I've documented it, and that's it. All the way up to if the conduct is really, really bad, the fact that they haven't got further warnings, or they're not on a first and final, or they're not on a final warning, is irrelevant. If they've engaged in misconduct, then it may be sufficient to sack, even though the disciplinary history is perfect. So it just depends. Your response needs to be proportionate to the seriousness of the conduct that you're dealing with.
Yeah. And just whilst we've got those slides on, one of the points that are probably worth addressing is two of the points. The first is condoning the practice in advance. So it comes back to that aspect of a fair go all around and making sure that we're treating that conduct consistently across the business. The second point is waiving the seriousness after the event. So if we're bringing the employment relationship to an end, and we're asserting that it's sufficiently serious to end the employment relationship, well, it can't be that serious if you've allowed the employee perhaps to remain at the business. You haven't stood them down with pay whilst the matter's investigated. So just bearing that in mind when we are bringing the employment relationship to an end, that if we're alleging it is sufficiently serious to end the employment, whether perhaps we need to stand the employee down whilst we complete some form of investigation.
That's right. It's difficult for employers to assert that it was super serious if you knew about it for 2 months and the person continued working for 2 months. It kind of undermines your argument. And the other thing that does come up sometimes with unfair dismissal matters is parity of treatment, so fairness of treatment. If there's inconsistent approaches, quite often you might see it in kind of applicants will say, well, there's a culture here of conversational swearing, or there's a culture here of banter, or there's a culture of, people similar other employees have engaged in similar conduct and they weren't terminated. So where's the consistency? So it is important to be consistent and to, if you've got a policy that says you can't do this and then you don't enforce the policy or you enforce it selectively, then that's going to go against you in any unfair dismissal matter. All right, just very quickly, termination on medical grounds. So that's another way in which the employment can come to an end. So that's an employer-initiated termination due to incapacity. The general kind of legal test here is whether or not the employee is fit to perform the inherent requirements of their role. Often you will need, almost always you would expect to have medical evidence to demonstrate that that is right. You do see that come up with long-term ill and injured workers, where you get to a point where the medical evidence is that the person's not fit to do the job, not only currently but into the foreseeable future. So that can provide a basis to terminate. Often there should be some level of show cause, or there might even be an IME report that you get to make good, or just to have some decent evidence that the person is in fact not fit to do their job. I'd normally recommend, almost always recommend at the very least some level of show cause process before you terminate someone due to incapacity. Summary dismissal, yeah.
Big one. So this comes across almost weekly, I would say.
Yeah.
It's a high bar. Serious misconduct is reserved for probably the most egregious forms of conduct.
Yep.
The test is that it's willful, deliberate acts by the employee that's inconsistent with the ongoing relationship. It's serious breaches of WHS, theft, fraud, physical violence, the like. One of the perhaps misconceptions with summary dismissal, though, is it's not an instant termination in that when you've observed it, you move to termination immediately. We'd still recommend an aspect of procedural fairness. What it is instead is once you form the view that the conduct is serious misconduct and you are moving to terminate the employment relationship, it's termination without notice. So the employment relationship ceases immediately from that point in time. You're not providing them with notice of termination and you're not paying them in lieu of that notice.
Yep. So summary dismissal is another way of saying termination without notice. The Fair Work Act or the NES talks about your right to not have to pay notice if there's serious misconduct. The Fair Work regulations define or provide a definition of serious misconduct, but it's a non-exhaustive definition. So it just kind of says serious misconduct includes all these things. It doesn't say it's limited to all those things. So it could be broader, but the Fair Work regs provision is probably quite a good yardstick for what is serious misconduct. The other thing to note is, again, contract and statute, you need a contractual right to terminate without notice. So even though the NES, you might not have to pay notice under the NES because it's serious misconduct, if the contract doesn't provide scope to terminate without notice in certain circumstances, then arguably under the contract, you have to pay notice or provide notice. But I think one of the points you're making is it is a high bar. More often than not, clients would raise it with us, employers would raise it with us, and we'd look at it and go, you're probably not quite at that threshold for serious misconduct or summary dismissal. The other thing occasionally is sometimes even where you are, there might be a good risk mitigation step to say, well, we think you've engaged in serious misconduct, giving rise to a right to terminate without notice. However, in the circumstances, we've elected to terminate with notice. You pay the notice payment. That probably de-risks it a little bit from an unfair dismissal perspective. So that's something that's worth considering as well. All right, I think that's kind of a very long warm-up to get to redundancy. But so we're now at kind of one of the focuses for today, redundancy. Most people would be familiar with what is a redundancy. The legal test or the definition is a redundancy is where the employer decides, so it's an employer decision, that it no longer requires the job being done by a person to be done by anyone into the future. There's a couple of technical carve-outs around the ordinary and customary turnover of labour, which we're not going to get into because it's almost a bit of a it sends people in the wrong direction thinking that they might be able to rely on that. Typically there needs to be, you see it in the contract cleaning sector where there's there's a commercial contract, with a government body or someone for cleaning services, and there's some case law that suggests that because it's all dependent on holding that commercial contract, if you lose the commercial contract, then people lose their job as a result of the ordinary and customary turnover of labour. There's a few cases fairly recently in the contract cleaning space where that exemption has been narrowed, in my opinion. So it's not as available as it perhaps used to be. For 95% of situations, it's not going to be relevant. Equally, insolvency or bankruptcy hopefully doesn't come up. So we're talking about we have a position that's no longer required. With redundancy, I always like to focus, I think it's helpful to focus on the position rather than the person. Mm-hmm. We're not making Kyle redundant, we're making the position redundant. And because of the position being redundant, we're now going to have to terminate Kyle's employment by reason of redundancy. But I'm not the thing that's redundant, it's the job that I'm doing. We've got there on the bottom of that slide, a redundancy situation may lead to an employee's employment being terminated, but it might not. So you can have a redundancy situation where the job ceases to exist, the employer no longer requires that job to be done by someone. It doesn't necessarily mean that someone's going to lose their job because, of course, there's redeployment opportunities, etc. So just bear that in mind. Redundancy is about the job, the role, the position, not so much the person.
So redundancy pay. So in circumstances where the redundancy does lead to a dismissal, redundancy pay becomes payable under the NES. Now, it's a sliding scale based on service. Some employees aren't entitled to it. So a common one is an employee who hasn't completed 12 months of service. Alternatively, if you're employed by a small business employer, so less than 15 employees, which is 14 or less, they don't have an obligation to pay. Another circumstance is the expiry of a fixed-term contract, if it's a true fixed-term contract.
Yep.
That said, there's also the ability for employers to apply to reduce the redundancy pay. Now, I certainly haven't experienced this very often, and I'm not sure about you. It seems to be almost a cost-prohibitive method.
Yeah, I think that's right. Like, there is scope to make an application to the Fair Work Commission to reduce the redundancy payable to an employee, either where you obtain other acceptable employment. So if you're instrumental in finding them a role with a third party, then you might then apply to say, well, hang on, I helped them get another job. That other job is acceptable employment, so it's kind of comparable. So I therefore want to be able to reduce the amount. There are times where the Commission will issue such orders. They'll often reduce it by 50% rather than reducing it fully. Incapacity to pay, you don't often see. I think the starting point from the Fair Work Commission is an expectation that you pay redundancy. The old GEARS scheme, which is now the FEG, so the Fair Employment Guarantee scheme, could kick in where if the employer can't pay redundancy such that they go into administration or liquidation, there's a government scheme that allows people to get their employee entitlements. The other thing worth noting just on the slide is, whilst there's exceptions for people who've worked for less than 12 months or in a small business, I think some of the modern awards can supplement the NES. Yes. And I think there are a few modern awards that say, well, even if you are a small business, you still need to pay redundancy pay. So you just need to be a little bit careful with some of those exemptions. And it's always good to go, okay, well, if you get to this point where you're terminating someone's employment, what does the employment contract say? What instrument are they covered by? So is it a modern award? Is it an enterprise agreement? What do they say about it? Often modern awards have that kind of fairly standard job search entitlement clause that says if someone's made redundant, or I think it's even if they've just terminated with notice, there's a right for employees to take a couple of days off without loss of pay to go to job interviews and things like that. So it's always helpful just to go and have a look at the instrument to see, what do the clauses say? What do I need to be aware of?
And so on this, just whilst we're on this slide, sorry, Kyle, there are a couple of questions specifically for redundancy. One of them was a question about voluntary redundancy, which is something that comes up every now and then.
Yep. So the Fair Work Act doesn't talk about voluntary redundancy or involuntary redundancy. I think the notion of voluntary redundancy arose historically through pre-reform awards, enterprise agreements, particularly probably unionised workforces where, let's take an example of a coal mine. The price of coal drops. They decide to scale back operations. They want to make 20 of the mine workers redundant. There might be a provision in that industrial instrument there to say, well, in terms of a redundancy process, you must first call for voluntary redundancies before you decide who to make redundant. So it's a process whereby employees can express interest in being made redundant. Often the people who express interest are those who've been there for a long time, who have quite a generous redundancy package awaiting them. Often you see people who are close to retirement age who might, have that entitlement. So some instruments might require you to call for VRs or voluntary redundancies. More often than not, most businesses won't have that situation, albeit if you want to, there's nothing prohibiting you from calling for voluntary redundancies, even if you don't have to. One of the downsides of VRs might be the employees who are the highly skilled, who are the highly experienced, who you don't want to lose. They might be the ones who express interest in voluntary redundancy. So you need to be a little bit careful about that.
Another question that came through was perhaps addressing that circumstance where we've got, you're looking to make multiple people redundant.
Yeah.
And how you go about the process of selecting who goes and who doesn't.
Yeah. So what we might do, if I just go back a slide. So talking about the definition of redundancy, in practice, you can see a few different types of redundancy situations. So a very simple one is we've identified that this single role is no longer required in the organisation. We might be outsourcing our IT function or something like that. We are making one role redundant. So pretty straightforward. There'll be consultation, redeployment obligations that we'll get to. Another redundancy situation might be the one that I just gave, which was we are reducing headcount by 20 people. And you might have 100 mine workers. You want to go from 100 to 80. So you've got to select 20 for redundancy. The question I think you're coming to is, or you've asked me is, well, if we've got to choose, how do we choose? What the Fair Work Act says in the context of genuine redundancy and unfair dismissal laws is the selection process must not be unlawful. But interestingly, in unfair dismissal cases, the Commission can't probe the selection process. So they can't say, oh, well, hang on, if I was in your shoes, I would have chosen different people. They just look at it and go, was the selection process lawful or not? So i.e., it can't be discriminatory. And you do see, just on that point, you do see some instruments that talk about last on, first off, which is, okay, well, whoever was hired most recently, you're first off in a redundancy situation. That's potentially unlawful. That could be age discrimination. That could be indirect age discrimination because it's going to potentially unfairly treat those younger people who are newer entrants to the workforce. So if you have to make that selection of, okay, I need to pick 20 out of the 100, what we would typically say is it's helpful to create some kind of selection matrix, which might be factors like, skills or capability, experience, qualifications, or, how highly they scored in their last performance review, attitude, those kinds of things, to effectively have a bit of a scorecard to select who you are going to retrench. Entirely valid to do that. You should do that if you're in those scenarios, and then that's effectively your defensive mechanism or your defensive document if anyone challenges it. You do want to steer away from things like, prior workers' comp claims or sick leave utilisation or absenteeism. They would be unlawful factors to take into account because that's effectively adverse action. That would be a breach of the general protections. So I think I answered your question about that.
Thank you.
You might even, in talking about categories of redundancy, you might even have another one where it's such a significant restructure that you hear the phrase spill and fill, where it's like we are killing off this organisational structure and we're replacing it with a completely new one and different. Therefore, we're effectively declaring all positions redundant. And then you have a competitive kind of interview process or selection process to then, everyone's been spilled, you then need to fill. You don't really see that much these days because it's not common to kind of make every role redundant or to change your structure so hugely. Awesome. Okay, so genuine redundancy. So that has a particular meaning in the Fair Work Act. There is an exemption in respect of unfair dismissal claims. So there's a section of the Act, I think it's 389, that says in order for a person to be able to bring an unfair dismissal claim, or in order for a person to be unfairly dismissed, it must not be a genuine redundancy. So it defines a genuine redundancy. I think it's up there, and we've largely talked about that on a previous slide. So it's the job that we no longer require to be done due to changes in operational requirements. But the thing to note here is, even if you meet that first dot point of, okay, it's a redundancy because we don't need the job, in order to meet the statutory definition of genuine redundancy, to have a defence or a jurisdictional objection to an unfair dismissal claim, you also need to have complied with any obligations to consult under an industrial instrument. So sometimes you do see a valid operational redundancy, but because the employer didn't comply with the consultation obligation, it then doesn't meet the test of a genuine redundancy, which means you don't have a jurisdictional objection, which means the unfair dismissal case can run. It doesn't mean you'll lose it, but there's a slightly different definition for genuine redundancy. The third element, which I nearly forgot, was it's not a genuine redundancy if it would have been reasonable to redeploy the person either within your business or within the business of an associated entity. So if you're a corporate group, you can't just consider that entity, you need to consider all the others. Hopefully that makes sense.
It does. Thank you.
Brilliant. All right, so on that note, we'll talk about consultation.
Yes, so modern awards are quite prescriptive in terms of consultation obligations. If you've got an enterprise agreement as well, it would likely be the same. It might be slightly different, but the general gist is the same. These are triggered where a definite decision has been made to implement major changes in the organisation, and those major changes are likely to have significant effects on employees. So there's a few elements there. I think the first one to focus on is the definite decision. I think a lot of clients come to us and they're ambivalent perhaps about the direction that they're wanting to go in, and they're unsure at what point in time the consultation obligations commence. It's when that decision is made. The next point is major changes. So the major change aspect is a consideration of the size and importance of the change. That might be in respect of the size of the organisation compared to the size of the change. You know, if you've got 1,500 employees, making 3 employees redundant might not be considered a major change. However, you know, if you've got 3 employees in a business of 15, that's a different aspect. The other element is significant effects. So this focuses on the employees, and how those effects of the change will impact the employees. So commonly that's termination of employment, loss or reduction in job opportunities, transfer to another location. This primarily is award covered employees or agreement covered employees. Conversely, for those employees that sit outside of modern awards or they don't have an enterprise agreement that covers them, there's technically no consultation obligation. So the Fair Work Act doesn't prescribe an obligation to consult. Review your employment contract. It's very uncommon for an employment contract to provide a consultation obligation. Now, if you're unsure perhaps about whether a modern award covers an employee or not, hedge your bets and just consult. The provisions are the same across the awards. So it's as long as you follow that general process, you're likely to comply with the consultation obligations.
I think that's right. Can I make a couple of comments on this slide? So you're right. So the model award consultation clause, the consultation obligation, as you said, is not triggered until a definite decision is made to bring about major changes. So if it is a proposed change, then you don't need to consult at that point and you're consulting too early. Now, I'm not saying you can't do it if you want to, you of course can, but the consultation obligation is not triggered until you've made a definite decision to make changes. So commonly in a redundancy situation, the company or the employer will decide to implement a particular restructure. It's at that point in time that they are consulting with employees. The consultation process in that context is about you are consulting on ways to mitigate the impact of your decision on employees. So you're not consulting about the proposal or even the decision. The consultation process is not really the time for the employee to say, hey, I want to change your mind. I disagree with your decision. I don't think you should do the restructure. Of course, they can say all those things, but really it is the employer makes a definite decision to do something. They have the managerial prerogative to do that. At that point, they then consult with the affected employees, and the consultation is about how can we lessen the impact. So if this role is going to be made redundant, are there other redeployment opportunities? Are there other things we can do? Sometimes you do see an employee who might be full-time say, oh, look, I'm probably happy to work part-time and I can work 2 days a week, and then you might come to some arrangement. There's often a misunderstanding on both sides of the fence, employers and employees, about when you need to consult. And equally, employees often will complain that the consultation wasn't meaningful or genuine or real because they didn't get an opportunity to change your mind. That, with respect, is a misunderstanding of what you're meant to be consulting about. So that's my first point. The second point is so this definite decision thing is coming from modern awards. Just bear in mind that there are lots of enterprise agreements out there where the consultation clause that's been negotiated and possibly been in place for some time actually says where an employer proposes to implement major change, you must consult. So obviously, if that's what the EA clause says rather than the modern award, then the time at which you need to consult is different. So just factor that in. And, with thinking about the recent election and the Labor government, look, I wouldn't be surprised if that's an area where I know the AWU, for example, have talked about this kind of consultation and the fact that if the employees aren't able to influence the decision-making process, then is it really meaningful consultation? So that might be, something I think of as potentially on the radar for reform. But as the law stands, you're only consulting under the awards, at least, after that definite decision is made. I think I said 2 points, but I actually got a third. So just very quickly, there is some case law that says, so there's some Fair Work Commission decisions that say, if you are a massive workforce with 3,000 employees and you make one person redundant, that doesn't actually trigger the consultation obligation because it's not a major change. My view, for what it's worth, is the way I would approach it is any scenario where you think that someone's going to lose their job, you should treat it as being a major change. You should assume that the consultation obligation is triggered and you should consult. Timing's often a question as well in terms of how long do we consult for? Is it 21 days? Is it 14? Is it 7? What do we do? There's no hard and fast rules in the Act. It's going to be proportionate to the significance of the changes. So if you're consulting with one employee, you've decided to make the role redundant, there's limited redeployment opportunities, then that consultation process might take 1, 2, 3, 4 days, compared to if it's a more significant restructure, it might be 3 or 4 weeks or more. We've probably covered all that. So I think that just the practicalities around that award clause, what it typically says is, once you've made that definite decision, you need to consult as soon as reasonably practicable after making the definite decision. You have to give people all relevant information in writing. You need to meet with people to discuss the changes and the impact of those changes. You need to give genuine consideration to the feedback that employees give. That is effectively the sequence of events for a consultation process. Of course, you don't have to necessarily give confidential or commercially sensitive information. But just bear in mind, the award says all relevant information in writing. So, redeployment.
Yes, so you touched on this before with genuine redundancy. So it's one of those elements that sit in there about whether it's reasonable in all the circumstances, and that's the test: is whether it is reasonable in the circumstances to redeploy the employee to perhaps another role in the organisation.
Yep.
The timing at which that's assessed is at the time of dismissal. So it's not done after the dismissal. If some role perhaps arises, it's at the time of dismissal. An important thing to note, and in determining whether it is reasonable in the circumstances, there's a number of considerations. One of the primary considerations, perhaps the primary consideration, is assessing the duties and qualifications that the role requires to be performed adequately, and comparing that to the duties and to the skills and experience and qualifications of the employee. And in circumstances where the employee doesn't have those qualifications, arguably perhaps it wouldn't be suitable to redeploy them. Conversely, if you have an opportunity for them to be redeployed into which they are skilled and capable of doing, the pitfall for some employers is they see that the role is perhaps a lower role, less remuneration, less hours of work, less responsibility. Now, that's not on the employer to decide. Arguably, that's for the employee to decide. So certainly put that role to the employee. And if they refuse that role, well, then we can proceed with the redundancy. If they don't, well, then they move into that role.
I think that's right. So you shouldn't assume that someone doesn't want a lower level role. I kind of flip it on its head and say, well, if you have available vacant roles within your organisation, the starting point is you should offer all of them to the displaced person or the redundant person, unless there's good reason why you're not offering them certain roles. So qualifications tend to be the kind of, if one of the roles is a vacant role is an air pilot and the person doesn't have a pilot's license, then you wouldn't be offering them redeployment into that role. But short of kind of having quite a hard, like they don't meet what's called the essential criteria for the role. If you think about job ads, often they talk about essential criteria, desirable criteria. I think if there's an essential criterion, which is, you have to have a particular degree or you have to have a trade qualification, and the person doesn't have it, I think that's a hard and fast, okay, they can't do the job. But if they can do the essential criteria, but they might not have all of the desirable criteria, prima facie, they should be offered redeployment into that role, because on your own version, that stuff is only desirable, it's not essential. So it's a pretty low bar for what you need to be offering up for redeployment. The big thing to note, which I think was November last year, was a full federal court decision, which is, I think, quite significant. So historically, the prevailing view would have been, you have to offer up redeployment into any vacant role or available role. But you didn't need to create a role for someone. And this full federal court decision from November last year, it was Helensburgh Coal, what the full federal court said there was, at that mine site, there were contractors who were doing similar work. And often you might also see labour hire workforces. So you've got labour hire people doing particular work. They said, the employee said, well, I should have been redeployed into one of the contractor roles. So i.e. you should cease the services of that subcontractor and give me that work. Typically, for the last 10 years or so, the expectation wouldn't be to do that. But the full federal court in that particular case said, yes, it would have been reasonable to redeploy. Now, that decision is before the High Court. There was a High Court hearing in March of this year and the decision's reserved. So watch that space in terms of to what extent you need to go, because that is a bit of a game changer for some businesses. All right. So we'll talk about navigating legal risks. I'm conscious of time, so I might just move through it pretty quickly. I think we've talked about most of the kind of legal risks as we work through, but it should go without saying, termination of employment should be handled carefully. It obviously is a significant decision. It has significant impacts on the individual. So you shouldn't kind of, approach it to, into laissez-faire manner. The main risks really, I'll jump back. The main risks are unfair dismissal and general protections. We've touched on some of that, particularly unfair dismissal. Most people will be familiar with unfair dismissal and GP claims. As I said before, for an unfair dismissal claim, it's about having a valid reason for dismissal. Yep. If you don't have a valid reason, then generally the Commission's going to find in favour of the employee. There's also procedural fairness considerations. So they'll look at, if it's misconduct related, did you give the employee an opportunity to respond to the allegations? If it's performance related, did you tell them that they were underperforming? Did you give warnings? Did you give them a reasonable opportunity to improve their performance? So just factor that in mind. Now, I think a good threshold as a consideration as well is the person covered for unfair dismissal law, yes or no? Because that might change the dynamic and change the risk profile. Some factors there, just bear in mind, I won't run through those, but bear in mind that the Commission has the power to consider any other relevant factor, any factor it considers relevant. So it's quite broad. And they do consider length of service, they consider geographical location, they consider job prospects of the person, they consider personal circumstances. So all of that can be relevant to their consideration. If we talk about general protections very quickly, again, most people will know what that means, but it's a termination of employment by definition will constitute adverse action. The question is, if you are taking adverse action, i.e. if you're terminating someone's employment because they exercised a workplace right, then that is unlawful and that will be a breach of the general protections provisions. So I talked about, probationary periods. Just because they can't bring an unfair dismissal claim doesn't mean that you shouldn't have a valid reason. Doesn't mean you should have a reason that's not unlawful. And ideally you communicate that to them, because if people don't have unfair dismissal eligibility, they will often bring a general protections claim. I think we've probably run out of time, Tom.
I think we have, unfortunately.
Hopefully we've answered quite a few of your questions just in the whirlwind hour of running through all those slides. I think to finish it off, we have some performance management training on the 3rd and 4th of June, if that's something you're interested in. As a law firm, we also have a bunch of toolkits out there on different issues, psychosocial hazards, flexible work arrangements, and sexual harassment. So if there's, if you're interested in any of that, jump on our website and have a look. Give us a call. Most of us are friendly people, so if we can help, we will. But otherwise, thanks everyone for joining, and we'll see you next time.